the issues of substance and the issue of perception, the optics. What would be the optics, my lord? The optics, my lord, as we sit here in public view, in the glare of Kenyans, some of whom, if you use the reasonable test, are professionals, people who have studied above Form 4, probably half the populations. The other half of the population are people who are definitely below Form 4. So what's the reasonable person's test here? And what are they seeing? The first thing, my lords and my ladies, that they are seeing is that the petitioners appear to be categorical for good or bad reasons, that they do not have confidence in the bench. And examinations of the fact may still prove that they may or may not be wrong. But the issue is the test, as far as when you read all these cases, in matters particularly that have some political angles, perceptions is everything. And perception is a big issue. So that, my lord, the issue therefore would be, shall we proceed on the basis where from the word go, the petitioners clearly have appeared to the rest of the country, they have got no confidence. With the same zeal and spirit, the respondents who are being accused for good or bad reasons are saying, we have full confidence in them. That should trouble us. Because at the end of the day, it is the coloration of whatever decision is made. It will be done from the prisms, oh, we told you, we knew this, they were going to do this or the other one. In huge cases like this, it should never be that way. I go to the second issue, the issue of the Honorable Attorney General. I listened to the Honorable Attorney General. The Honorable Attorney General has made an application, one of the applications to set aside the orders. I went back to Article 156. 156 on one hand suggests the Attorney General is the President's lawyer. There is another clause, I don't know whether it's 11 or something like that. It suggests that the Attorney General is the guardian of public interest. And you ask yourself, the Attorney General, without doubt, when it becomes to the President, he's 100% sycophantic, a President's lawyer.
But my lord, when it comes, raising a new issue, that
which is the
never
new issue,
part of the recusal application.
That is not a new issue, my lord. Let me proceed. My lord, the Attorney General is the guardian of public interest. What is the public interest in a process of impeachment as we stand here today? My lord, that public interest must be the country has been treated with an imperfect, I'll not go to the details, with an imperfect impeachment process at the National Assembly and at the Senate. When it reached towards the tail end of this process, the public will be treated to the fact that in processes that presupposed that you would take about 75 to 100 days were conducted within hours. So that the bigger questions, my lord, would be that there is a complaint that is being made, a serious one, of the right to fair hearing and human dignity. Rights that are not derogatable under the Kenyan Constitution, even during an emergency. My lord, if you are faced by an Attorney General who, pursuant to one mandate, their conscience has not been touched, that there is some public interest in looking at these things a little bit from the perspective of the Deputy President and those who feel like the Deputy President, that a fair and square deal has not been granted by the processes that have taken place. Your Lordships, that should concern us. I go to the next issue, the main issue that he cannot deny, he did say. My lord, you are being told that we are in serious danger, we are in the throes of chaos or something like that, and there is some danger. My lord, the truth of the matter is, the time that has been prescribed, thank God, by the Constitution itself, they are far from over. And the petitioners here keep saying, and the Honorable Muite has told me, tell the court that if the court can be able to hear us from next Thursday when all of us have done responses and whatever amendment, we are ready to conclude that issue. We are ready, we know the timelines. So that, my lady, the connection, therefore, of somebody saying that, oh, the only public interest here, and this is the Attorney General, is that we must swear by hook or crook before the petition has been heard. That also should be a matter of grave concern.
Sure, because there was never a submission like that, and I think counsel must have some respect for the truth. Nobody said anybody must be sworn by hook or crook. Please let's respect the truth.
My Lord, I think the language always in submissions belongs to counsel, but what Professor Gedhu Muigai, my former teacher, said is this, that we are in the throes of instability, something to that effect, because if we do not complete the process that was started by the National Assembly, a huge power vacuum might arise. And that it is why, when I use hook or crook, it is why the only obsession that we hear, oh, it's conservatory order taking out. That is the context. My Lord, I go to the next issue. Who is this who made the oath of office of Professor Ojenda? My Lord, there was the question of CTS. The question of CTS, I believe, had dealt with it, and all those kind of issues, and we pointed out that the issues of CTS, whereas we had talked about them, they appeared for the first time not from the respondent's affidavit, but from the ruling that the court made. I don't need to say anything about it. The respondents had said nothing about them. My Lord, to Professor Ojenda, there is a question of... no, I have to respond. There is a question of the internal memo. The question of the internal memo, again, that was not a matter that was ever placed here in any affidavit, as far as I'm concerned.
That was yesterday's submissions.
I think you were here.
I think these are notes for today.
Those are notes for yesterday.
No, these are notes for today, my Lord.
That was yesterday.
No, my Lord. If they have a date and I had a different notebook, but they would get uncomfortable. Let me pass that. In fact, he's not the main guy I have to deal with.
But counsel, do you think it's right to refer to a document which never featured during the proceedings?
My Lord, in my notes, I captured that when he was talking about all these issues, he talked about the internal memo. My Lord, well, if he says he didn't, let me hope I imagined it. I can pass it. But that's what my note says. I don't mind. We can't fight over a memo. And as I said, we are dealing with some other submissions. My Lords, my Lord, there is a question of Mr. Nyamodi. And Mr. Nyamodi was talking about the issue of the...
My Lord, this time is up. Just sit down.
He was trained by Gibson.
Their own document.
Just to confirm, we have not touched his notes.
Will the court allow me to remind him what I said?
No, the only misplacement was this guy.
My Lord, maybe we should correct that as well, because it's been said 3 times. There are no guys in court. They are learned counsel.
my learned colleague, Professor, is the only issue, the reference, senior counsel. Is that doubted? My Lord, the issue that would require the clarification, let's go to Kerogoya. I believe there is no doubt about the issue of Kerogoya. My Lord, the issue that was raised, and I believe this is the last point that Professor Muigai was making, regarded the issue of where it was alleged that the issue estoppel with regard to the issues of Kerogoya that found themselves in the ruling of yesterday. And my Lord, first of all, I wish to point out that there is a notice of appeal that is one of the annexures in the supplementary affidavit and raises specific issues about preempting and the issues dealing with matters that were yet to be handled. I need to clarify that is one of the issues when it talks about the issues of res judicata. And when it comes also to the issues of res judicata, it is important, my Lord, that it is pointed out what was the subject matter of yesterday's application. It was the interpretation and application of Article 165(4) of the Constitution in relations to the powers of the Deputy Chief Justice. The said ruling, anything else that may have been said that was outside that direct issue that was before the court, that was not an issue for that ruling. And therefore, dealing with matters that are outside there and you are be told the ruling has dealt with those matters which it ought not to have dealt with, so it has become res judicata. It cannot become res judicata in our submission. My Lord, with regard to the issue of the friendships, I think this is something that they have been preoccupied with. My Lord, nobody is trying to criminalize friendships, not at all. But my Lord, there are always degrees of friendships. When it is alleged, for example, that a friendships between Kibe and Ndegwa is of such a close proximity that Kibe and Ndegwa ought to disclose that fact to any other person, it would be different, for example, to my friendships with Harvey, somebody we just meet and do a few cases with. So that, my Lord, the issue at the end of the day is one of degree. To what extent are there interactions between these two individuals? Because, my Lord, and we were saying that you may feel that there are issues. Issues could well be raised. That who was so that, for example, was Judge Mrima from the Kenya Law Reports records, as people would be sending materials to indicate that, the lawyer for Mheshimiwa Kingi during the case with Esposito? Again, the answer would be yes. So this is not a casual friendship. It is a friendship that is over. There have been had client-lawyer relationship, other personal relationships are all there. So that, my Lord, you cannot be able.
Now, how do we respond to that?
Mr. Kibe.
Yes, my Lord.
I had intended to restrain myself.
Yes, my Lord.
From interjecting in these applications. But I think the statement you're making is factually incorrect. In the Esposito matter, I appeared as the advocate for IEBC, yes, not Mr. King.
Yes. Thanks for the clarification. My Lord, the issue...
I think if we people can respond on issues of law, it would really help us, rather than going back on issues of facts.
Yes, so that, my Lord, there was a question of forum shopping. Forum shopping, I go with what Mr. Ndegwa has said. If this bench recuses itself, it does not mean that we shall choose any of the judges that may replace this bench. My Lords, on the issue of Mr. Moshemi's submissions, my Lord, Mr. Moshemi's submissions, we start first of all from the premise that Mr. Moshemi did not have a replying affidavit. We did not have a replying affidavit. I tried to object. In order, you said I respond. We want just to draw the court's attention that if you want to take factual deposition, you take somebody else's affidavit that has been deposed to on oath and say, this is not true, you did not sign here, you did not do this, you have not subjected it to any examination or anything. That would be completely to go outside the rules of evidence as we understand them. And therefore, for as much as the issues of Mr. Moshemi is concerned, I urge this court to disregard them. There are two other more important issues that we need to point out. My Lord, using the test of the reasonable man and woman in Kenya, it is a question of splitting hair. President Ruto and Tuya. Is splitting of hair for the simple reason that during even the Senate proceedings themselves, we were treated to a situations in which, and one of the principals was indicted, in which political positions at cabinet, board levels, and others were toss-ups for purposes of political dealings. The average knowledge, because that is the standard that you've said, a reasonably informed Kenyans is aware that any new government comes to office with its own appointees to those board positions, permanent secretaries, and others.
Mr. Kibe, you are going beyond what is really necessary for this. I think you have made your submissions. Respect the court and your colleagues. Reply on issues of law, please.
I thought that was an issue of law. My Lord, I finish with the question that was raised by the one without an affidavit by Michael Moshemi. The issue of Mr. Michael Moshemi, where you are told that for purposes of gauging bias, you should be able to look at the MP for Madeira, who did not, who voted against the deputy president, although he was his father or something in the wedding. My Lord, the direct reference to that would also have to be taken from the bar, the way it was also made from the bar, and the direct reference to that is that the wife of this MP.
My Lord, that's a question of fact.
Yes, it was also the same question of fact.
Let him reply to points of law, my Lord.
We should understand what we mean by matters of fact. Questions of when, who, where, what happened, who did this, who did that. Those are all matters of fact.
My Lord, the only exception, and we said, when we tried to stop, to stand to say that Moshemi is dealing with those issues, you told me, my Lord, you will respond. So I ask that I respond to that issue. That's the last issue. And the response is this, that the wife of that Madeira MP is also on record as having said that I voted against the DP Gachagua because he insulted us and said our wedding will not last. It had nothing to do with impeachment charges. So that we cannot ignore that is what he said, and it is on public record. So that, my Lord, the long and short of it, so that, my Lord, the long and short of it.
Mr. Kibe,
yes.
How do I record that?
No, my Lord, the way you recorded, I think I saw a record from the other side.
What you are saying?
Yes.
How do I record it?
Well, I don't know who recorded, but he was allowed to say in open court that even his own MP voted against him. So to be able to demonstrate whatever point he was making. And I'm also saying that from the bar, let it also be made clear that the wife to the she's also an honorable MP, said, I voted because the DP said that that marriage was not going to last. Not on impeachment. So that, my Lord, the long and short of it, because we've had a long evening, is that I beseech this...
I suppose the marriage still subsists, right?
It still subsists. and we also hope, my Lord, that when we are that when we are hard with this petition, the tenure of the DP could proceed. So that, my Lord, the last point that we need to make is that there is somebody, I guess, who is a doctor, and something that Dr. Camino has said, a moment of introspection. This moment of introspection is important. Because for you, my Lord, the issue at the end of the day would remain that an important case is up for determination. Besides the information that is here, if your councils were to show what is it that other things that are coming up in the course of the proceedings, that questions of perception is such a huge issue, my Lord, that if you are to apply the old rule that you are being told to apply, that you have a duty to sit, anybody who does not come with a smoking gun, disregard it and sit nevertheless. My Lord, that would defeat the meaning of let justice be done and be seen to be done. But more importantly, it would also affect my reading of chapter 6, the one that would be said that if there is somebody questioning, like the DP, he has written a complaint, it may be right, it may not be right. And it may be upheld, it might not be upheld. But, my Lord, the question is, as we await for that day, should any appeal or anything that results from this case relates to the issue that related to the conduct of the judges, or we deal with the issue of the moment? My Lord, with those submissions, I urge you respectfully, weighty as an enormity of having to argue this application, hold as we have tried to convince you, there are more than reasonable grounds that in existence, that there would be something wrong if one were to say, I will disregard all these issues on technicalities and proceed anyway. I thank you very much, Your Lordships. Evans, oh, sorry. My Lord, Evans, there is an authority. I've been under a lot of pressure that he needed to say something about it. And he's part of me.
What will be, how will others respond to the authority?
No, he's answering the authorities that were used, cited.
My Lord, just note that he has no right of reply.
No, I'm leaving.
We're in the same team.
In the same team.
My good friend, Mr. Wanyama.
Yes, he's actually filed the application.
Thank you to the court. I am fully aware of the long